research. As I told you previously, we have 7 researchers, and for today, this is Professor Judith Jasko, who is joining us without voice, but I suppose the next time it would be just shared with Professor Ferenc Santha, so we could see how it will work. Maybe we would give the supplementary voice to Professor Judith Jasko. So our research team consists of Dr. Peno, that you could see. Dr. Peno is from Szczecin University. His research fields are quite broad and include also the general theory of law, some aspects of criminal law, and some I can say reflection about sociology. We have also Dr. Magdalena Kowalewska-Lukuc from Szczecin University, so this is the same unit. Dr. Kowalewska-Lukuc is attached to the Department of Criminal Law, and she's a psychologist. She has an LLM title in psychology, so I suppose she could share with us some thoughts in this area. Also, we have an excellent researcher from Hungary, Professor Adam Rixer. I had honor to work with Professor Rixer previously with the first edition of Polish-Hungarian research platform, and Professor Adam Rixer is from Catholic University, from Reformed Church Catholic University in Hungary, in Budapest. He is a head of Department of Administrative Law, and I suppose it would be the field of research in our mediation area. And then we have Dr. Ferenc Santha, Associate Professor at Department of Criminal Law, and Professor Judith Jasko. They would be participating together, preparing together some kind of research. Professor Jasko, as I told previously, auxiliary researcher, and they represent University of Miskolc, Faculty of Law, and I can say that maybe there would be the time to share some thoughts together, because as you can see, mostly in our performers, we have the representative from the criminal law fields, mostly, except from Dr. Zombory. She is mixed researcher, Polish and Hungarian, and her field of research is rather international law, and she's going to deal about mediation, negotiation aspect in the field of private international law. So as you can follow our title of presentation for today, we have this very introductive formula, just preliminary remarks of our areas, but mostly they go for a criminal field of research with the impact of Dr. Peno with this social sciences aspects. And I have the mixed interest in research, because mostly I must present myself now. I'm a professor at Department of Criminal Procedure at Adam Mickiewicz University. But some aspect of my research, I dealt with them during my habilitation time, when I prepared the habilitation book, was connected. They were connected with general theory of law. So this is in some part my area of research still, and I can mix them with my interest as a specialized in the criminal law, especially procedure field. So I hope that everyone could share some general thought about the research during the presentation. And now I can switch my role, being a moderator, to be someone who is sharing the first thought. And I would like to explore this general approach. And first, the word for excuse why I'm speaking as a first, because I thought firstly that I would be this one who is going to conclude the seminar, but actually my research could be combined with the others. So maybe some thoughts of mine would be inspiring for your research, and maybe you could then during today's presentation try to make some connection with them. So this is a reason why I'm speaking as a first. So I prepared here the four areas of research which I'm going to follow, taking into consideration theoretical and methodological approach, of course, in some way connected with the philosophical approach as well. So firstly, I would like to deal with a theory of conflict resolution approach as a basis for understanding mediation in criminal procedure, which is quite complex because on the one hand, we have the many works on mediation in criminal field, but this is very particular in the systems because there are many elements that must combine to, as Dr. Peno is going to deal today, make the negotiation, restorative justice work. So it is like very complex issue, and I'm going to enrich this approach, quite renowned, so TSR approach, with the theory of communicative act approach, mostly concentrated on the thoughts of Habermas. So I would like to create a general vision how to describe negotiations in this absolutely comfort way for all the participant of negotiation. And then mediation could be seen from this theoretical point of view as a conventional act based on Austin theory of speech acts, and as by this approach as an element for legal argumentation approach. So how to create this this space for discussion. And the last one is quite not very widespread in the research at international field, but it is taken from very famous work of Hisholm, so-called paradox of this author. So this is a contrary to duty obligation approach, and this is a concept. We could describe it in general formula that the author inquired why do some systems contain norms that somehow imply a violation of the other norms. And here we have make space for restorative justice. So you see my area that I would like to explore. And as I told you for today, because the time is quite limited and I won't exceed my time as a moderator, as speaker for today. Actually, I was a little bit surprised by this formula that I have this 15 minutes for all my duties for today. But I would like to share with you some thoughts about the first aspect, but not all of them. But I don't see the problem because we can continue with this topic during the August seminar. So first of all, some terminological aspects which are quite basic, but I think that it is important to when I would like to create a purely methodological and philosophical basis, it is important to introduce them when the research is keeping in English. So first of all, we have two models of criminal justice, a consensus model and conflict model of criminal justice. And it is important to say because we are going to use those notions, consensual and conflictual model, but it is important to emphasize at this point that those terms are strictly reserved and created by philosophical approaches. That consensual model is built on the concept of John Locke's social contract theory, and the last one, the conflict model of criminal justice, based on Marxist ideology. Of course, we are fully attached to the first one, so the consensual model of criminal justice. Even if I would use the name, the term conflict model of justice, it doesn't have any connection with those theoretical model of criminal justice. Just an excuse, but I would like to say this to not introduce anyone into a confusion. And then, so we are still speaking about those conflictual aspects at this formula, conflict resolution theory. It would be my theory to develop, and in this part I would like to deal about alternative dispute resolution. So speaking about theory of conflict resolution and criminal law, we must find some very important connection, because as I told you, my research will be connected with general theory of law, but examples, because I'm specialized in criminal procedure, are from criminal field. So it is very important to introduce those general notions to interpret criminal procedure at the example of Polish criminal procedure. So first of all, the crime as a source of conflict. And of course, this is very important to directly say this, that there are many types of crime, and types in general, I mean types of crime with victims, with injured person, victims as human beings, and crime offenses without them. So the field for negotiations are strictly connected with the substance of criminal law, substantive aspect of the part of criminal offenses type. And then in my opinion, we have to follow those distinctions to properly describe the area where negotiations and where restorative justice could appear in proper way. And then when we speak about this general theory of conflict resolution, we have to discuss about the parties of the trial. And here we have very important approach, general approach, whether the system in consideration is inquisitorial or adversarial. When the system is mostly inquisitorial, like the Polish legal system of criminal law, the space for negotiation and position of negotiation, it is still, I will use this notion, offender-driven. So everything what is about negotiation is rather attached to offender than to victim. So I would divide those systems as the offender-driven systems and the victims-driven systems. So it would be the next step of the methodological approach. So the situation of victim is very particular, because in general we have the victim, it's only one part of the notion injured person. As we all know, injured person, it is a legal person and human beings who are injured by an offense in direct form. So we have to discuss where is the space for those entities who are not human beings, and whether there's a part for negotiation to them. And the last aspect at the basis is about those models, retributive justice and restorative justice. And it would be the last point for me today to discuss. I know that it is very broad and I prepared 24 slides, but I would describe this further later and during our workshop for the participant of the seminar. So I would express my opinion for a compatibility approach. So it means that in my research, I'm not skeptical, but I'm rather for this option of collaboration of retributivism and restorative justice. So just to conclusion to this, to be like clear with what I'm thinking. This is here, not here, but later. So my conclusion, it's general assumption admitted at the basis of negotiation, is that we have to combine retributive and restorative justice in some point, and it is very important to find the space. And restorative justice, of course, cannot operate alone because it's inadequate in many fields of criminalities. And retributive justice and restorative justice are two processes for dealing with crime, each with distinct features, but with same goal. And as far as, and this is my last statement for today, as far as restorative justice and actually retributivism is in combination when the punishment is human and rehabilitative. And from this part, I would like to describe those driven defendant and driven victim models and different other models which could be taken at the basis for mediation at the field of criminal law. So thank you for today. Only 2 minutes. I exceeded my time. And the next speaker for today, so now switch the rule, is Professor Rixer. Professor Rixer, I presented in general Professor Rixer at the beginning, and I suppose that we will have many occasions to present basically in many forms. So Professor Rixer is going to share with us general questions of the mediation in administrative law, so his field of research and Hungarian perspective. So Professor Rixer, the floor is yours.
Thank you very much, Barbara. Good afternoon, dear colleagues. It's an honor to be part of the second Polish-Hungarian research platform, as it was a privilege to be part of the first one as well. Previously, my topic was the legal aspects of the relationship between public administration and civil society in Hungary. And now the title, the topic is mediation within administrative court proceedings in Hungary. Under the provisions of Act 1 of 2017 on the Code of Administrative Court Procedure, a brand new institution has been launched in Hungary in 2018. From the 1st January of that year, in administrative court proceedings, the judge may, with the agreement of the parties, impose a court mediation procedure in the cases in which the law does not preclude it. My current research is primarily concerned with the description and examination of this phenomena that is the mediation within administrative court proceedings and is made up of the interplay of three components: former rules, actual legal practices, and thirdly, narratives attached to the law, encompassing everything from the goal of the institution, the public discourse surrounding it, to social attitudes toward the institution. Consequently, the primary method to approach the topic is the review of the relevant primary legal sources, actual law in the form of constitution, fundamental law of Hungary, acts, governmental decrees, court cases, and so on, and also secondary legal sources through which we may define relevant scientific problems, create our own definitions, and prepare a catalogue of practical problems specifically for Hungarian issues regarding the topic. I hope The latter can serve as a useful addition to legal and other debates which might take place in various European and domestic public arenas and will predictably re-emerge in the period following the COVID-19 pandemic. The COVID pandemic has necessitated remote hearings around the world as courts seek to dispense justice in spite of logistical hurdles preventing in-person meetings. Moreover, those new needs and answers given have raised also questions beyond the issues of technology. And undoubtedly, that overview of practical problems also requires interviews with judges and other mediators, anticipating the written conclusions with the contemporary and up-to-date findings and opinions. So the work employs a socio-legal approach. The second step of my research and study, right after the enumeration and brief overview of legal sources that are currently in force, has to be an analysis that aims to collect and analyze data from articles, journals, and other publications on the topic of mediation in administrative court procedures in Hungary. My task is to review the content of the articles published in Hungarian academic journals from 2015 to 2022. The findings suggested that topics such as the introduction of the certain provisions of the new administrative codes have been over-researched, and on the contrary, topics such as the practical conclusions of the first 4 or 5 years still offer wider opportunities to be researched. To be more clear, those researches are almost completely missing. Scientific paper studies both in criminal court proceedings and civil court proceedings show several examples on the examination of the theoretical and practical questions of mediation in Hungary. However, the content of materials related to mediation within administrative procedures, and especially in administrative court procedures, show the very opposite characteristics in Hungary. We have only a very few of them, and even those concentrate on the introduction of current legal institutions without a systematic overview of the practice, of the daily practice. So, what should be the good research questions? Moreover, what could be the novelty and the contribution of that research, of such research? First, one of my hypotheses is that the general practice of the reconciliation of interests within the Hungarian society, for example, the quality of consultative mechanisms devoted specifically to the economic and social dialogue, and also citizens' trust in the national authorities, or the features of the Hungarian litigation culture, are all elements of the broader social context of the mediation within administrative court proceedings, strongly determining the latter. The question to be answered is, what are the main characteristics of the broader social environment of specific forms of mediation in Hungary? What type of mediation is the best for that context? Second, international scientific studies outline the possibility of a so-called multi-door courthouse or multi-door courthouses in which litigants could be triaged into the most appropriate forum for their individual dispute, such as mediation, arbitration, or litigation. Is it a real scenario for Hungary? And if so, would this work in administrative cases? Third question. ADR, or alternative dispute resolution scholars, have long touted the many advantages of non-litigation options for disputants. Those advantages include cost and time efficiencies, creative problem solving, confidentiality, party autonomy, and control over the process and outcome, and flexible and accessible processes. But What are the Hungarian reasons behind that institution? What are the certain advantages that differ from the same of others, if there are any? Fourth, what are the cases in which the current law does not preclude mediation? Mediation is not a suitable procedure for settling disputes in all administrative cases. So, what are those cases types in which that kind of mediation is most frequently used in Hungary? Should we broaden the scope of case types? Fifth, and it's my last question, what is and what should be the content of materials of the training courses that prepare the mediators for new challenges? In general, what makes a good mediator within this specific field? So these are, and these should be, the main subtopics covered by my research. Thank you very much for your attention.
Thank you very much. Even 4 minutes before time, but I highly appreciate your attitude, because you know this is Sunday, and it is our all fault that this is Sunday, because we started a little bit later. So I decided to go for the last day of July. So this is Sunday, and everyone count the time. So thank you very much. And I would like to ask our dear next distinguished performer, Dr. Ferenc Santha, with the presentation on introductory remarks in the frame of Hungarian criminal law mediation, of course. The floor is yours.
Thank you, Professor. Thank you, Barbara. It's also an honor, a great honor for me to be here and to be a participant in this research group. I try to share my PPT.
So just using the time, please do it. It is a very good option to send the presentation before seminar to the organizers, because then you could share this easily by the link.
Okay, so in this occasion, I don't use the PPT. So the title and the topic of my short presentation is, as the professor mentioned, is introductory remarks in the frame of Hungarian criminal law. My subtopics will be first the ranges of interpretation of victim-offender mediation in Hungary. The second is the objective of the mediation in criminal cases. The third is the main legal sources of the mediation process in Hungary. Then the two types of mediation in Hungarian criminal law, and if I will have time, some words about grounds for refusing mediation. First of all, the ranges of interpretation of victim-offender mediation, according to Hungarian scientists. First of all, victim-offender mediation, I'm sure, is one of the most important form of restorative justice. It's a cost-effective form of diversion from the criminal path, a way to avoid criminal court proceedings. It can reduce the burden of the criminal justice system and accelerate the criminal procedure. And mediation can be a useful mean for resolving conflicts related to or caused by the crime. And if we are optimistic, mediation can reduce recidivism and facilitate the reintegration of the offenders into the communities. And the next subtopic, the objectives of the mediation process, according to Hungarian legal rules, according to Hungarian Criminal Procedure Code. The main aim, the main objective of the procedure is to reach a written agreement between the victim and the offender in order to giving a compensation for the consequences of the criminal offense, encourage the future law-abiding conduct of the offender, and settle the conflict between the victim and the offender with the involvement of a person independent from the authority, independent from the investigation authority and from the prosecutor as well, who the person will be, of course, the mediator, who can be a probation officer or a lawyer, attorney at law in Hungarian legal system. And the next question, what are the legal sources of mediation process in Hungary? I have to emphasize that victim-offender mediation has been introduced into Hungarian criminal law on the 1st of January 2007. So the legislation is based on three pillars. First of all, the Article 29 of the Criminal Code, which regulates the so-called active repentance as a ground for exemption from criminal responsibility. These are the substantial criminal law rules. The articles of the Criminal Procedure Code, which contain the relevant criminal procedure rules. And we have a background act. We have a special act from 2006 on mediation in criminal cases, which regulates the mediation process in details, the rights and obligation of the parties, the duties, tasks of the mediator, and so on. I have to emphasize that Hungarian procedure, victim-offender mediation procedure, is of a mixed nature, since in Hungary the prosecutor has a right to suspend the criminal procedure and transfer the case to mediation if the statutory conditions are fulfilled. The prosecutor's decision is followed by the mediation process, which is, of course, a non-criminal procedure between the victim and the offender, carried out by the mediator. And the next, the two types of mediation process, because currently there are two forms of mediation can be distinguished in Hungary. The common element of the two forms of mediation is the central role of the prosecutor. I have to emphasize that mediation process was also possible at the court stage until the 1st of July 2018, but currently only the prosecutor may decide to transfer the case to mediation. It's an interesting question. It was a good decision. I think it will be one of the aim of our research to answer the question: it was a good decision or not. So the two forms of mediation in Hungary. The first is mediation process in order to apply active repentance as a ground for exemption from criminal responsibility. This is the so-called traditional mediation in Hungary, where the scope of the relevant crimes are limited. And the second, the mediation process in order to make reparation for the consequences of the offense and to obtain a lighter sentence. This can be named the new form of mediation, which is applicable to any crime, at least in principle. Traditional mediation is applicable in criminal cases in Hungary if the criminal offense is a misdemeanor. This is the less serious crime in Hungary, or a felony, this is the more serious form, or a felony punishable with a maximum imprisonment of 3 years. And the offense is limited, as I mentioned, and the offense is a traffic offense or an offense against life, physical integrity, or health, offense against personal freedom, human dignity, and other fundamental rights, and offense against property or intellectual property rights. In this situation, in case of a successful mediation, the criminal procedure is to be terminated. The perpetrator cannot be punished. And if the above-mentioned felony is punishable with maximum 5 years imprisonment, it's a more serious crime, of course, the successful mediation will not terminate the punishability, so the case goes to trial, but the penalty may be mitigated by the court without limits. So this was the traditional mediation, and the second form is the new form of mediation, which can be applied from the 1st of July in 2018. The most important element of this type that it is not linked to active repentance, and it can be used in criminal proceedings for any offense in which the objective of the mediation can be achieved. Its purpose is to make reparation for the consequences of the offense and to obtain a lighter sentence, as I mentioned, and the scope of the relevant crimes is not limited, so this time of mediation process applicable to more serious criminal cases. And there of course, there are common features of the two types of mediation process in Hungary. First of all, the initiation process, because the suspect and his or her defense counsel and the victim also has a right to file a motion in order to start the mediation process. On the basis of these motions or ex officio, the prosecutor has a discretional right to transfer the case to mediation process and suspend the criminal proceedings for a period of 6 months. The second condition is, of course, the suspect has pleaded guilty until filing the indictment. The next element is reparations for the consequences of the crime are expected. So this is a condition which will be decided by the prosecutor, of course. And the next element, the criminal proceedings may be omitted, or the mediation process is not be contrary to the principles of the imposition of penalty based on the nature of the crime, the method of the perpetration, and the circumstances of the suspect. I have to emphasize that this latter condition is at the discretion of the prosecutor. Consequently, the prosecutor has a decisive role in transferring a criminal case to mediation. And the next element, the next condition is, of course, restitution. Namely, the suspect shall provide restitution by way of the means and the extent accepted by the victim within the framework of the mediation process or previously, if approved in the mediation process. And finally, I think the most important element of the process and this legal institution is restoration or reparation activity, because in mediation process the agreement is only concluded if the victim and the accused have agreed to compensate for the damage caused by the crime or to otherwise make reparation for the harmful consequences of the crime. Very important question, I think. What can be a reparation? What can be a compensation? So I have to say that compensation can be provided in any form if it is not immoral or illegal. It all depends on the needs of the victim and the parties' agreement. This means that material compensation, a personal service, the physical repair of the damage caused, or the offender's promise to undergo treatment or therapy for crime prevention purposes, or any other solution by the parties are all acceptable. Okay, I think my time is over. So this was the last sentence in this occasion. Thank you very much for it.
Thank you very much. But your time didn't expire. It's 5 minutes left, but we started in this very good discipline, so we could keep with this. And I just have one thought that it would be very insightful to us, taking into consideration comparative approach of our team. Maybe for the next time, could you highlight some basic aspect of Hungarian model of prosecution? Because what I can observe after your speech today, it is even more, from my point of view, a settlement agreement-oriented mediation formula than in Poland, and it is even maybe more prosecutorial and inquisitorial process. So I think that we could maybe make this observation. Would we need to make the right comparison between both systems? It's my suggestion. Maybe during discussion we could think about it to give each other impact, how to develop the research to make them very fruitful for each other. So thank you very much. And we can, I don't know whether Dr. Kowalewska, who is the next speaker, could join us with camera, because I think and I see that she's struggling. Yes, yes, I can hear you. Dr. Kowalewska, to be honest, is very nervous, I suppose, because she's struggling since the beginning with her camera and microphone. And I can say that during the first meeting, organizational meeting, I had the same problem. So it's properly founded. Sometimes with this application, it's about the computer, personal computer, but sometimes it doesn't work. So don't worry. Could you join us? I cannot hear you and I cannot see you. Dr. Kowalewska, could you hear me? Because I think that whether you have some doubt about your connection, please don't worry. And we could maybe go to Dr. Peno right now, and you could have some supplementary 15 minutes just to resolve your trouble without nerves. So, Dr. Peno, what do you think? Could you take the place of Dr. Kowalewska?
Thank you, of course. That's a great
idea.
Could
you be so helpful? Because I know that is extremely nervous. Actually, I'm always nervous with new applications, so I properly understand, Dr. Kowalewska, that it's really when this whole devices made us crazy. Like, I think that it is very, very well founded. So, Dr. Kowalewska, please try to resolve your situation and join us, and we will try to connect you after Dr. Peno, and if not, even after the presentation recorded by Dr. Zombory, because we have presentation recorded by Dr. Zombory, who is during her vacation period, like she couldn't join us really, and it is properly founded. So, Dr. Peno, I think that you could deal with us about your very as you said, acquiring question, putting into dispute. So, because Dr. Peno is going to deal about the formula of legislation at the end, and his topic for today is making a mediation and restorative justice work, administrative instrumentalism versus reflectivism for reforms. So this is your title?
Yeah, okay. Yes. I'm here. I hope that you can see my presentation.
Yes, with very detailed description. So the floor is yours.
Okay, thank you. Okay, so scope of considerations, mediation, especially in public law, especially in criminal law, because of course in civil law the matter is quite simple. Of course, mediations or making mediation living law depends on a kind of education maybe. But of course in public law and criminal law, especially in administrative law, it is problematic. And here we have mediation, restorative justice, some conceptual remarks, how to introduce institutions such as mediation, organizational culture and values in the judiciary, values behind mediation. Well, the question is, I can't see you when I have presentation open. It's a quite strange experience.
This is open.
The question is why we assume that mediation or restorative justice is better than a classic justice. The answer, to my mind, lies in the axiology. So I will try to concentrate on axiological problems. Of course, I'm a philosopher and also I'm a sociologist, but I have personal practical experience in mediation and in restorative justice, as I cooperate with the government of Basque country in a process of introduction or application restorative justice to penitentiary system. It's a great practical experience. But of course, today I will try to say, I guess, about three first points from this agenda. Mediation and restorative justice. Speaking generally, in the nearest future, I'm going to examine both successes and failures in Polish practice of restorative justice. Of course, every society engages with restorative justice in its own distinctive way, as it is the society that is always on the receiving end of restorative solutions. I will not discuss main regulations or institutions about restorative justice or mediation, especially because for me the law is not enough. We need to change something more in our communities, in our societies. We need a kind of cultural change in our legal culture. And I would like only signal now that we have also a conceptual and conceptual problems at the stage of the meaning of words, understanding of concepts. It's troublesome, for example, about restorative justice. And I assume that mediation as an institution should be part of comprehensive solutions, changing the way we look at the justice system. I call this conventionally restorative justice. And let us consider how the justice system works in criminal, family, juvenile cases. Is there a place for mediation, for restorative justice? As a sociologist and philosopher, but also a practicing mediator and probation officer, I do interested in the social and cultural context of legal institutions' operation. This is why I'm talking about restorative justice and not only about mediation, because in order to introduce mediation in our legal systems, we need to change much more than the procedural law. I think that the biggest obstacle to mediation is a kind of legal tradition and habits of lawyers, judges, prosecutors, attorneys of the law. Let's be honest, restorative justice and also mediation as a process is long, expensive, and we cannot be sure of success. Ordinary justice, classic justice, offers a chance for a quick end to the dispute. We cannot make mediation a legal institution similar to institutions that we know from courtrooms. So this is why I'm try to concentrate on a problem of organizational culture. Okay, then we have another slide. I hope you can see it. Administrative instrumentalism versus reflectiveness for reforms. I assumed that there are two model ways to implement restorative justice. Restorative justice in its conventional meaning of this concept. It seems for me that the Polish restorative justice system is an example of operating based on erroneous assumptions. In Poland, restorative justice and also mediation is considered as the autonomous goal of criminal policy per se, which is achieved by the mere introduction of institutions similar or that reflect to some extent form of restorative justice. It is assumed that this institution justifies itself, but without real debate, we cannot be sure that it is actually good in all respects. Moreover, to be successful, restorative justice must be based on previously social reforms and a broad education. Paradoxically, I believe that restorative justice is a means to an end, but at the same time, we must be careful about excessive instrumentalization. For example, treating restorative justice in terms of increase the productivity of the punishment system. Another slide. Here we have. Maybe here. As you can see at this slide, there is no clear concept or conception of restorative justice. Of course, before we try to shape institution of restorative justice or institutions of restorative justice, because we can consider restorative justice as a set of institutions, legal institutions, we first have to choose a model of changes or reforms in our legal systems and changes in thinking about justice. Among many different orientations, approaches, and concepts, there is no clear picture of what restorative justice is to be, where to locate restorative justice. We know that it is supposed to serve something good. Restorative justice is supposed to serve something good, but it is an evaluative category and unfortunately a subject to instrumental interpretation. And here we have some very general ideas, very general thoughts. I would say that consistency is the key to success. This is maybe an obvious conclusion, but restorative justice deals with delicate issues, and this idea does not always live up to the expectations of the public, and politicians have to reckon with that. We know that penal populism is what penal populism is, and we know examples of this. And here we have a list of, I would say, problems that I identified, taking into consideration the history or evolution of Polish regulations in the field of restorative justice. I'm not going to read it, but just to show. And here we have practical problems. These practical problems are connected with this slide. I hope that I can go to the next one, to this one. Here we have, given that the concept was introduced at the time, the concept of restorative justice was introduced at the time when the Polish society was creating a new democratic reality, it was also hoped that mediation could serve as a fast-track remedy and act as an ancillary mechanism. But in fact, in the case of Poland, it seems that the exceptionally limited interest in mediation and in the paucity of anticipated outcomes of victim-offender mediation is the big problem, this practical problem. So here we have, there is no coherent system combining social assistance, legal aid, and the judiciary. Attitudes of employees of the judiciary, of course, it is also a problem. I think one of the biggest problem why the mediation is in fact dead law. Politicians, they declare something different, then they change thought, the change idea, the change criminal policy. Of course, the role of non-governmental organizations, of course, and values are of a facet character. It is, for me, great problem also, because as I said in the beginning, what is why we believe that mediation or restorative justice is that it's something good, that it's good to introduce this kind of solutions. The answer lies in the axiology, but we need to reconstruct axiological background. So here we have conclusions. What we I would like to share here my general thoughts on what should be done, tested, and considered, so that restorative justice, in the broad sense of the word restorative justice, which is about a certain qualitative change, could be implemented as a living law. So here are 5 points. I think that the last one is the most practical, whereas the second and the third, and especially the fourth point is it's well, mostly axiological. It's also very, very important. So we need a qualitative change, social, cultural, axiological, in thinking about law as a conversation, not a tribunal, not quantitative, shown in reports under the slogan faster, more, cheaper, and so on and so on. We need a qualitative change, and for me, our role as a mediation research team is to find, to explain, to describe this axiological, in fact, background of legal institution. There is a great conception in Polish legal theory, the conception of principle in descriptive sense, or descriptive meaning. I think that this is on the previous slide, perhaps. Yeah. So maybe something there. So I think that that we have to concentrate on this axiological aspect of restorative justice or mediation, if you prefer this word, to describe this kind of legal solution. Yeah. So thank you very much. I hope that I'm not late. Thank you.
Thank you very much. Dr. Kowalewska successfully achieved her results. So she is with us, and she can turn on her microphone, and so the floor will be her. Just the small conclusion of after your speech, Dr. Michał Peno. So I think that this is a next speech that improved, that we have to discuss even the basics, like the models, how the model should be created, because when speaking about the mediation in criminal law, it is always about the position of mediation versus criminal trial. And the place for mediation could be only in the trial when the rules for the victims are properly elaborated, and the impact of privatization in some aspects is admitted. So in this type of proceedings, I think that our common research with Hungarian friends would be very insightful, because it could be an example of purely inquisitorial prosecution and the place of mediation in this kind of system, because mostly when dealing about mediation, we speak about adversarial models, and even mediation itself and this type of restorative justice is taken from adversarial model. And in comparative analysis, there is an approach that this form of mediation, I mean a concept, has been translated to the quite different models, and it cannot work in the same way, in the same formula. So thank you, and I hope that we could discuss this later or during our workshop. And now the floor for Dr. Kowalewska-Lukuc. I'm very happy that you are finally with us. I hope that you can share your screen, because I could see your presentation for a while, but now I cannot see. But don't worry, you can go without presentation. It's very good that you are with us. So please take your time.
Okay, good afternoon, everybody. First of all, I would like to say sorry for these great technical problems. It's the first time when I couldn't turn on microphone, camera, anything. And I really getting so nervous that I will be unable to be with you today, fully be with you, with the sound and with a picture, but I am here. So I would like to say that I am very happy to be part of this project and to be the part of this research team. It is a great honor for me, but also a great challenge, maybe even bigger now after these technical problems. But moving on to the subject of my presentation, I would just try to show you the presentation. Just give me 5 seconds. Just a moment.
Okay, so maybe I can give my thoughts about the role of Dr. Kowalewska one more time, because I see that we could all be very interested in your inquiry into the position of victims in general, the different time of victims in the VOM, so victim offender mediation concept, because I suppose that there is a really place for restoration when it is my thought, because I at first I was many years ago, like 10 years ago or 15 years ago, I was rather skeptical about mediation in criminal procedure in this type of proceedings, inquisitorial proceedings, because of many actually features that Dr. Peno presented, like the time taken, not result granted, but the position of victim could be protected in very good way, because this is a space when victim could find a way of rehabilitation, to not be a victim for the second time, so re-victimization aspect. And I hope this would be the area of research of Dr. Kowalewska in our further meeting. So Dr. Kowalewska, could you open?
I'm sorry, I just changed the computer to be with you, and I forget to send this presentation.
No, this presentation is here. I can see you. I can see the presentation at the presentation on the left.
On the left. Oh God.
You could see a camera, then a screen, and this is a place, and I can see your presentation. If not, I can maybe open your presentation.
Can I ask you to open it, because I'm afraid I have no ability to do it now.
But if not, it's for sure our assistant, because she helped me as well. It doesn't work when I'm trying, but okay.
I see it now. Thank you. Great. I will just let you know when to check this.
No, you can do it. Okay? You can do it by yourself.
Okay. I'm afraid I can't. Okay.
You can.
I can. Great. Okay, let's start. So, as we can go now to the subject of my presentation, I would like to outline how mediation is currently regulated in Polish criminal proceedings. When we think about mediation and its purpose in criminal proceedings, there is quite obvious that we try to attempt a voluntary resolution of the conflict caused by the crime, that the parties should reconcile and agree on a way to repair the damage caused by the offense and to compensate for the harm suffered. This goal should be achieved, of course, with the assistance of an impartial mediator and throughout the conclusion of a settlement agreement. But it should be noted, however, that the mediation in Polish criminal proceedings appeared with the 1997 Code of Criminal Proceedings, I mean CCP, so quite late. It was not present in the 1929 CCP, nor in the 1969 Code. The emergence of the institution of mediation in Polish criminal proceedings can be interpreted as an expression of the Polish legislators turning towards the idea of restorative justice and a certain shift of focus in criminal law from total concentration on the perpetrator, so characteristic for the psychological school, towards noticing the interests and position of the victim. Michał Peno told us a little bit about restorative justice, but in my paper, I would like to focus on the current shape of mediation in Polish criminal proceedings. I would like to outline and analyze it as it is, which I hope will serve me and us as a whole research team in the future to diagnose problematic issues in the Polish regulation of mediation and the practice of its application in criminal proceedings. And maybe it will allow us in the future, again, as a whole research team, to formulate possible postulates de lege ferenda. In the 1997 CCP, mediation was initially regulated in Article 320 as one of the provisions of pretrial proceedings. This gave rise to serious doubts as to whether a case could be referred to mediation only at the pretrial stage or also at the trial stage. This doubt was dispelled by placing, by the amendment from 2003, the regulation concerning mediation in Article 23A of CCP in Division 1 of the Code, entitled Introductory Provisions. It is already clear that the institution of mediation refers to the entire criminal proceedings. The provision of Article 23A of the CCP regulating mediation was amended in 2015. At that time, a new regulation of Minister of Justice was also issued to define the detailed procedure of mediation. I have to change the slide. And I really can't do it. Professor Janusz-Pohl, can I ask you to change the slide because it's impossible for me? Thank you very much. Okay, the current regulation of Article 23A of the CCP defines the authorities that can refer a case to mediation, the grounds that allow to do so, the maximum period of mediation, and the entities that cannot act as mediator. A more detailed regulation of mediation in criminal proceedings can be found in the mentioned regulation of the Minister of Justice, which additionally specifies the detailed procedure for conducting mediation, the conditions which have to be fulfilled by institutions and persons authorized to conduct mediations, the manner of appointing and dismissing mediators, the scope and conditions for making case files available to the mediator, and the form and scope of the report as the result of mediation proceedings. I will discuss next the current shape of the institution of mediation in Polish criminal proceedings, resulting from the content of Article 23A and from the mentioned regulation of Minister of Justice. I will try to analyze the conditions of mediation proceedings, the mediation procedure itself, together with its possible finalization, the issues related to the person of the mediator, and the principle of mediation in criminal cases, which can be observed in the background of mentioned legal regulations. If I can ask again for change the slide of the presentation. Searching in content of the Article 23A of the CCP for the conditions of mediation, only one can be easily decoded. I mean the requirement of consent of the victim and the accused to refer the case to mediation. It should be noted here that consent is an absolute condition for initiating, but also for conducting mediation proceedings. It can be withdrawn at any time. However, it is rightly pointed out in the doctrine that the consent of the victim and the accused is not the only one condition, and not all criminal cases are suitable for mediations. I mean, not in all cases, mediation will be an appropriate solution. Above all, mediation is supposed to be in the interest of the victim. Yeah, it's obvious for us, I think. This, moreover, follows directly from the 2012 European Union Directive, which the current form of Article 23A and the CCP is intended to implement. It is difficult to identify a priori the categories of criminal cases that should not go to mediation. If there are any criteria or generalized limitations, it is possible to state that the circumstances of the case should not raise major doubts, and that the accused should not dispute his or her guilt. The importance of circumstances that are not necessarily related to the act itself is also relevant. I mean, the nature of the conflict between the parties, the type of relationship between the perpetrator and the victim. For example, it can be family relationships, neighborhood, collegial, professional relationships. I think also circumstances concerning to the accused person are important, such as his or her previous criminal record, demoralization, mental health condition. And finally, the circumstances connected to the victim, such as claimant health conditions, are also important, and let us think about if mediation in this specific case is really suitable. Yeah? Research conducted in Poland on the use of mediation in criminal cases shows that it most often takes place in cases of offense against the family and guardianship, and more specifically, the offense of maltreatment. The second group of cases that were most frequently referred to mediation were cases of offense against life and health, primarily participation in a fight or beating, causing medium bodily harm. The third group of cases, which appeared relatively frequently in the mediation studies, were cases of offense against property. In addition, a great number of cases were referred to mediation for the offense of criminal threats, defamation, causing a road traffic accident with moderate bodily harm. However, there were also mediations for acts such as rape, for example. Yeah, so it can be seen that practice has taken a flexible approach to the institution of mediation. In consideration of the parties to the mediation proceedings, the accused, suspect, or the victim, it also becomes an obvious condition for mediation that the criminal proceedings have reached an appropriate stage. I mean, at least in personam stage in the pretrial proceedings. From the moment of bringing the charges, we are dealing with a suspect, yeah, as a person who can participate in mediation with the victim. Analyzing further the stage of criminal proceedings in which mediation might take place, it should be stated that it may be both the stage of pretrial proceedings, of course from the in personam stage, and the court stage, both during the proceedings in front of the court of first instance and next during the appeal proceedings. Can I ask for changing the slide of presentation? Thank you. When discussing the procedure of mediation, it should first be pointed out that the case may be referred to mediation by a court or a court referendary, and at the stage of pretrial proceedings also by a public prosecutor or another body conducting such proceedings, for example, the police. referral of a case to mediation is made by court order. There is no right of appeal against this order. The order should specify the name of the institution or the name of the person appointed to conduct the mediation proceedings. The order should also contain the details of the accused and the victim, an identification of the act, together with its legal qualification. A time limit for the mediation proceedings should also be set. By the way, proceedings of mediation should generally last no longer than 1 month, but it's fully instructional deadline, so it's 1 month only on the paper, yeah? Upon appointment to mediate, the mediator should immediately establish contact with the accused and the victim and set a date and place for a meeting with each of them. The mediator should then conduct individual or joint preliminary meetings with the accused and the victim at a time and a place convenient for them, during which he explains to them the objectives and principles of the mediation proceedings, instruct them on the possibility of withdrawing their consent. Yeah? Following these preliminary steps, the mediator conducts a mediation meeting with the accused and the victim at a place and a time convenient for the participants, of course. In doing so, he or she helps to formulate the content of a possible settlement between the accused and the victim. Mediation proceedings shall not, in principle, be held on the premises occupied by the participants or their families, nor on the buildings of the authorities entitled to refer the case to mediation. In the ideal arrangement, the mediation proceedings end with the conclusion of a settlement agreement, between the victim and the accused. In any case, however, also if no settlement is reached, the mediator prepares a report on the results of the mediation. This report is then submitted to the authority that referred the case to mediation. A key element of such a report is an information on the results of the mediation proceedings. If a settlement agreement has been reached, it shall be, of course, attached to the report. The subject matter of the settlement agreement is most often the issue of compensation for damage and harm suffered. The mediated settlement agreement can then be made enforceable. Can I ask for changing the slide? In defining who may be a mediator, it should be noted first and foremost that mediation proceedings may only be conducted by an institution or authorized person entered in a special list. Such a list is kept by the president of the individual district courts. The mediator, all in all, must be impartial and inspire confidence in both the victim and the accused. What is particularly important from the point of view of the further course of the criminal proceedings, the mediator may not be questioned as a witness as to the facts of which he or she has become aware from the accused or victim while conducting the mediation proceedings. A mediator may be now a person who enjoys full public rights and has full capacity to perform legal acts, is at least 26 years old, has a verbal and written command of the Polish language, and has not been validly convicted of an intentional crime or an intentional fiscal crime. Such a person must, moreover, have skills and knowledge in conducting mediation proceedings, resolving conflicts and establishing interpersonal relations, and must be able to guarantee the proper performance of his or her duties. Okay, can I ask for changing the slide? Having already discussed some of the elements that make up the construction of mediation in Polish criminal proceedings, certain principles, certain principles that should govern mediation proceedings can be outlined. There are the principle of voluntariness of mediation, the principle of confidentiality, impartiality of the mediator, and neutrality of the mediator. We can change for another one. It remains to see what the objectives of mediation are in general now, yes, in criminal law. As I have already pointed out, mediation is obviously intended to lead to a resolution of the conflict by means of an agreement and to compensate for the harm caused by the offense and to make reparation for the harm suffered. It also, of course, gives the victim some sense of justice and compensation taking place. But subversively, we may ask, what does the offender get out of all of this? First of all, pursuant to Article 33, paragraph 3 of the Criminal Code, the court should take into account positive results of mediation when determining the sentence. Under Article 60, paragraph 2 of the Criminal Code, a positive result of mediation may even affect extraordinary mitigation of the sentence. However, the most far-reaching effects of a positive result of mediation can be achieved in private prosecution proceedings. In private prosecution proceedings, the effect of a positive result of mediation is that the proceedings are discontinued, and the offender is therefore not criminally liable at all in that case. In cases of offenses prosecuted on request, a positive outcome of mediation may translate into the withdrawal of the request. And the last slide, from the outlined regulations on mediation, it seems to follow that it should work quite efficiently in Polish criminal proceedings and be used quite often. Meanwhile, statistics indicate that only a small number of criminal cases go to mediation. This may suggest the existence of some problems or limitations, or both, in the application of this institution, which are not apparent at the first glance in the analysis of the construction of mediation de lege lata. It also suggests the need for a more thorough examination of the institution of mediation in Polish criminal proceedings and a diagnosis of potential problematic issues. Paradoxically, a specific regulation and practice of the so-called consensual modes of ending criminal proceedings may be the answer here. Without going ahead, I would like this research area to be the subject of my paper at our next scientific seminar, in August, and the topic may be the topic of the chapter being prepared for our monograph, but it is all for the next weeks and months of our work. Thank you very much for your attention, and once again for these technical problems before.
Thank you very much. Maybe I will wait with sharing my thoughts about your presentation after we can hear and see the presentation of Dr. Zombory, because our time is not very flexible. So I can ask our assistant to start the presentation of Dr. Zombory. Send it. Oh, thank you. There it is.
Dear Director Wielec, dear Professor Janusz-Pohl, dear colleagues, thank you very much for the invitation to the Polish-Hungarian Research Platform and for the opportunity to join it as a member of the research group on mediation in court proceedings. I'm very sorry that I cannot participate in today's meeting in person, but I will do my best to join the next group meeting. My name is Katarzyna Zombory, and I am a Senior Research Fellow at the Central European Academy, which is part of the University of Miskolc in Hungary. Originally, I graduated from Maria Curie-Skłodowska University in Lublin, in Poland, but for more than 10 years now, I have been living in Hungary. I work here as a legal researcher, and I'm also responsible for the Polish-Hungarian scientific cooperation and academic exchange in the area of law. I am a public international lawyer, and my main field of research is human rights law and international cultural heritage law. However, I have always been very interested in intercultural communication, mediation too. I am a certified mediator. I'm accredited by the Hungarian Ministry of Justice, and I'm also a member with the Cross-Border Family Mediators Network and with the German MEC, which is an international mediation center for family conflict and child abduction. In 2019, I participated in Berlin in the Cross-Border Family Mediation training, which is an intensive training course for family mediators to mediate cross-border family disputes with the so-called 4B mediation model, which includes bilingual, bicultural, biprofessional, and bi-gender co-mediator team. I must say that I practice bilingual and cross-cultural mediation almost every day at home, with my Hungarian husband and our bilingual and binational twin daughters. And I must say that sometimes it can be even harder than the MIG training in Berlin. But more seriously, coming back to the subject, in the Polish-Hungarian research platform, in the group on mediation in court proceedings, I would like to deal with the topic of mediation and mediated agreements in international child abduction proceedings. Cases of cross-border child abduction are particularly challenging because they usually involve a highly escalated family conflict, different cultural background of the parents, significant geographic distances, and complex cross-border jurisdiction issues. And last but not least, it involves a child who has been retained or wrongfully removed to another country by one of the parents, often in a conspiracy and secrecy, a child without any knowledge or understanding of the family situation. In cross-border abduction cases and return proceedings, mediation can prove to be a very valuable tool of conflict resolution, which can be beneficial for all the interested, conflicted family members. It offers a possibility to achieve amicable solution in a relatively fast and cost-effective manner and in the best interest of the child. However, sometimes the cross-border recognition and enforcement of successfully mediated family agreements poses serious legal difficulties. On the international and European level, there is a complex legal framework which regulates jurisdiction, applicable law, and enforcement of decisions and agreements in the area of family law. This framework becomes even more complex if we add to it the domestic legal regulations of family law in states concerned. In this project, first of all, I would like to explore the international legal framework relevant to mediation and mediated agreements in the international child abduction cases. Secondly, I would like to examine Polish and Hungarian domestic legal regulations for the cross-border recognition and enforceability of mediated agreements. I would like to compare them with the findings of the experts group within the Hague Conference of Private International Law on the cross-border recognition and enforcement of agreements in family matters which involve children. At the end of the project, I hope to be able to identify and express some de lege ferenda recommendations as well. This is my research concept, and thank you very much for your attention.
Okay. Okay, thank you very much, Dr. Zombory, who is not with us, but maybe could then later, because our seminar is recorded, so she can then, after she will be with us, maybe she can record her whole seminar. So thank you very much for this participation to let us know about the field of research and projected ideas to be researched. Maybe this could inspire other researchers, like, for example, Dr. I'm so sorry, but someone is calling. I'm sorry. By tips. Maybe this could inspire, for example, Dr. Kowalewska-Lukuc, because there are some cases that you could have in common from the field of criminal law when is the question of kidnapping children, because this is very often linked with the family cases with international impact. So maybe we could even moderate a little bit our research. So just to conclude the seminar in short word before opening discussion, because it's only 1 minute left, I would like to say that we could have quite broad impact, taking into consideration that it was seen as introductory seminar, what we are going to research, and we have mostly this peanut sphere of analysis to be researched then, but with a very important impact to administrative law from Hungarian perspective and as international aspect of private law in the family cases. The general conclusion, as I can formulate right now, I think that it is clear for me that the need for victim-offender mediation must be seen from the broader perspective. So I can identify my approach, this general theoretical approach, maybe as important for all of us and also for me, because we must see mediation and the most important aspect of mediation for us, mediation in formula discussion approach of mediation. So not this formula settlement agreement mediation that we have in Hungary and in Poland, because this is a mediation when offender is a center of concentration. It is not the formula when it is victim driven mediation. So maybe this is just a basic hypothesis for Dr. Peno how to make this mediation work, and for Dr. Kowalewska-Lukuc, for Dr. Santha, and for me as well to think about for the other and combine this with other previous thoughts. So now I can open discussion, and I think it would be good to give some comment by us, so by the participants. So maybe in the order that we have given our speeches, okay? So maybe I can ask Professor Rixer if you would like be so kind and share with us some thoughts. And I will wait for some maybe asking questions from the public. I will observe the chat. And then I can take the formula to read the question from public, and maybe there are some passive participant who would like to take a floor and share with us some thoughts. Maybe Professor Judith would like to share with us her observation, how to improve the seminar for the next. So maybe firstly we could give our comments in order following that presentation. So Professor Rixer.
Thank you very much for your valuable presentations and thoughts. And though unfortunately I'm the only from the field of administrative law, I think that I can add some important things to this whole process, to this research project, because as you have already underlined, the cultural context of mediation is really important, and as it was clear from my presentation, we have to speak more about these elements of that broader social context, and I'm looking forward to these conversations. Thank you very much.
Yes, okay, thank you very much. And Dr. Ferenc Santha, please, could you share with us your thoughts?
Yes, just one sentence. I have an impression on the basis of the presentation of Magdalena that the legal regulation on mediation in Poland is rather developed, detailed, well developed, and but on the basis of the presentation of Dr. Peno, the situation is not so good. Mr. Peno painted a rather dark picture on the situation of restorative justice and victim offender mediation. It's very interesting because in Hungary there are opinion that victim offender mediation is a success story. So I think that it will be useful for us that we will examine, for example, the relevant statistical data in Hungary in relation of mediation and the opinion of the practical lawyers, not only lawyers but mediators and the representative of the profession. Thank you.
Okay, thank you. And actually, I had this impression during when comparing the speech of yours and Dr. Kowalewska-Lukuc, and I'm a specialized the field of criminal procedure, so I'm quite aware about whole problem of mediation from this practical point of view. So I had even this impression that maybe our group mediation in procedure is founded because in Poland mediation is not very it's developed when taking into consideration this framework, normative framework, but in practice it's not so impressive. And maybe example of Hungary, it's a better example to use it as improve the Polish mediation. So maybe if it was even the thought behind our research team to be constructed. So then please, maybe it would be the time for Dr. Peno. Would you like to share some thoughts with us?
Yes, thank you very much. That was very there were very interesting presentations. I would like only add that we need values because it's really important. I think, and very practical. In fact, we need values because there are certain values behind every legal institution. To shape a legal regulation, we need general principles rooted in values that we can show to the legislator. These are issues related to the theory of legislations, how to create model institutions. This is why we have to examine the axiological background and context, and maybe there is why a reason why mediation in fact it doesn't work. I can't remember, but that is around 1% of cases are solving by mediation in Poland. So why and how to change this situation? This is a very, very important question and very practical, because if we will manage to reconstruct axiological background, we will I hope that we will manage to give a roadmap how to introduce mediation or restorative justice to our legal order, not only legal system but legal order. Which
in
of
practice,
course also,
law in action aspect. But just I had this impression when speaking about axiology, because I researched this aspect as well, and it is like okay, but there are many level of axiology, and even when you look for the proper philosophy for restorative justice in Christian philosophy, there are some very improved thoughts for retributivism, and the same, it is like more contemporary level of Christian impact to retributivism. So there are some values behind those attitudes. So finding a proper axiology, it's not that easy that we could think at first. So thank you very much. And then next, I would like ask Dr. Kowalewska-Lukuc, and if, of course, Professor Judith would like to share with us some thoughts, it is, of course, place for Professor.
Okay, thank you. I agree that we need to look at the mediation more broadly, to think about the original formula to frame mediation, to think about the position of the victim and really pay attention to the position of the victim in the whole mediation proceedings. We have, we have in Poland quite extensive legislation about the mediation, and it seems to be quite well written. But not many cases go to mediation, as Michał Peno pointed out. The question is why, yeah? And I think this question I would like to work on in our project. Maybe it is necessary to go back to the beginning, to the idea of the mediation, as Professor Janusz-Pohl at the beginning tell us. We will see, but obviously, in Poland, these regulations about mediations are a little bit, maybe not dead, but not used in a broad scope.
Okay, thank you very much. Though this is our question today, this is a practical question, but very well founded from the theoretical point of view. And Professor Judith Jasko, would you like to share some thoughts with us?
I would like to thank for the hearing the presentation. It was very interesting for me to hear the several approach, and I would like only one sentence is to say. I think mediation cannot be effective in practice without a change of approach, and I think Hungary is successful because it was in the practice change of approach. And thank you very much.
Thank you very much. And I'm just inquire our chat because I'm there are some comments. There are some comments on mediation. Of course, I can only announce that it is just first seminar, so we didn't fully share our thoughts on mediation. Just we tried to elaborate the very broad scope of our research and to build a platform where it's possible to take this from this comparative point of view. And as we can see, it is possible at the field of criminal law, but it doesn't mean that the administrative law cannot help us to understand better the circumstances, how to create the proper mediation. My hypothesis is maybe I would like to share with you more during our workshop plan. As we discussed, it's not open workshop, but just for our team, that we need to see mediation, see the chance in mediation for the victim to be treated better by criminal justice, and it is not explored in Polish practice. So I think that it is our main practical and theoretical challenge to be addressed. So I can inquire one more time a chat, and this is okay, but I cannot see any question to anyone. Just comments. So please, could you follow the comments, because there are sometimes addressed to someone person. So I can ask one more time. There is anyone who would like to ask the question to the performers, maybe just to comment in this broader formula, not exactly linked with the presentation. Maybe I can ask about the help of our assistant. Could you help me to be sure that there is anyone who would like to ask the question?
Yeah, I cannot see any more messages on the chat. There are a few thoughts, but there are no questions.
No questions. So this is a time to close the seminar, this open seminar and recorded part.
Yeah, I would like just thank you very much for the presentation made by all members, and I also thank all the passive members for their attendance. I can see that several people from the other research platforms run by the Institute have logged in, so thank you very much. And now I will turn the recording live on Facebook, and if the group feels to the need, then please feel free to take up the discussion and talk in less formal atmosphere. I officially thank you very much for the meeting.
Okay, thank you very much. So I think that we could use this opportunity, just 5 minutes, okay?